Hello, my name is Michael Scott, and today we're going to be going over some of the disciplinary actions and themes within counseling state and local boards for the state of Virginia. So, what are some common reasons for disciplinary actions as they pertain in Virginia? I went through the Virginia Department of Mental Health's website and looked at the past couple of years of reasons for disciplinary actions. I had to filter through when looking through those for counselors specifically, as opposed to quality QMPHs and things like that. And surprisingly, it seems that a majority of the cases seem to be dual relationship issues, primarily sexual relationships. The other common ones are billing issues, some kind of minor issues with charging people late fees and things like that that they may not deserve. Moving on, some of the themes along with these dual relationships is it appeared that there was kind of two separate types of dual relationships that commonly occurred. One was explicit sexual relations with clients, and the other was kind of innocuous, more innocent dual relationships, such as getting a little too involved, maybe opening yourself up a little bit too much, or just having an unprofessional relationship with clients involved. That leads to some form of inappropriate or unprofessional work, unprofessional kind of action by the client that often causes harm. Moving on to a specific case, I chose the last case that was adjudicated towards a counselor in the state of Virginia, which is an incredibly disturbing case. So if anybody has issues with sexual abuse, I would suggest that you not watch the rest of the video. Mr. Clotes was a residency in counseling who violated essentially every ACA code and state code by engaging in a sexual relationship with a minor through 7 months of therapy. There was sexual insertion, there was masturbation, there was over 76 deleted videos that he was sending to the child. He confronted the child at the child's bus stop, attempting to get him to delete videos and things of that nature. Eventually, of course, he was found. A warrant revealed incredibly disturbing things, such as the child taking video of his sibling and sending it to the resident counselor, and a whole host of very disturbing things, such as sex toys for children at this individual's house. Now, in terms of which ACA codes he violated, it's more easy to say which ones he didn't violate, which would be, Section F, because he was in residency, he didn't have issues with supervision. Obviously he did, but he wasn't the supervisor. He didn't do any research for Section G and for Section D. Relationships with other colleagues, there wasn't really per se an issue there. Maybe there should have been some relationships with other colleagues. Ultimately, his license was suspended. He was ordered for continuing investigations, and while it is not public record at that on the DMHP website, I'm sure other actions were taken from law enforcement, obviously, considering that some of these things occurred from finding warrants. As far as the state codes go, there is a host of state codes under the Administrative Code, Standards of Practice 18 VAC 115-20-130. B1, endanger the welfare of the client. B5, documentation, termination procedures. B7, disclosure of methods used. B9, the goals of the treatment. All of C, which deals with record keeping, and all of D, which deals with dual relationships. Moving forward, we were supposed to look at impairment and what does the ACA and our state codes say about impairment. There's one small section in the ACA, section C.2.G, that deals with kind of what to do in an impairment type situation. You're supposed to monitor your own health, excuse me, refrain from offering services if you feel that you may be impaired, and then most importantly, you have a duty as a counselor to assist colleagues in, kind of determining whether or not they're impaired, speaking up, saying something like, hey, are you all right? Like, you're coming into work late, you don't look so good, things like that, just asking those questions. As far as the state goes, There isn't any specific code or regulation. B6 kind of talks about making appropriate arrangements, but this is mostly for one's untimely death or vacation. But there is some guidance from the state board, 115-2, that explains how a license can be denied in the event of physical illness or disabilities or chemical dependence. And these are all forms of impairment that can impact the licensing. Last but not least, was there a specific question to come to mind? Reading some of the disturbing sexual relationships, many of these occurred from counselors that were still within their residency. And specifically, the last one was a 7-month relationship that was incredibly explicit and incredibly involved. And it makes me wonder, what are the laws and regulations regarding supervisors, and how could this go unnoticed for 7 months? This has to be some failure of the system and failure of the supervisor involved. Like, I know some supervision requires, video documentation and things like that. That would have stopped almost all of this. But even still, why was the supervisor not checking in on clients when you have a counselor that is essentially fresh and, only has a degree and what limited experience from internship and previous experience, obviously under 2 to 4 years. It feels like there's clearly needs to be more laws and regulations to watch for this kind of behavior, because it seems to be happening consistently within resident counselors. Thank you for your time.